Thank you for joining today's See You on the Weekend lecture webinar entitled Indigenous Rights and Developing International Law. We'll be starting the program in just a minute or two to get everyone a chance to get logged on. Thank you for your patience.
Welcome to See You on the Weekend, an ongoing series of lectures featuring cutting-edge faculty creative work from the University of Colorado Boulder. Today's webinar is titled Rights of Indigenous People and Developing International Law. My name is David Means, and I'll be your moderator. I'm the director of the Office for Outreach and Engagement, which sponsors this series. We're so glad you could join us for today's program. A few logistics before we get started with the presentation. Attendees may submit questions by clicking the question and answer button, which is located at the bottom of your Zoom window. These will be sent to the presenter and the moderators for their consideration and will not be visible to the other audience members. Due to the size of the lecture, and we have more than 250 registrants today, the chat function has been disabled for the talk. We may not have time to get to your question, but we will certainly do our best to address the themes and ideas that are most common. So please do submit your questions throughout the talk as they occur to you. This will give us a chance to review them and sort them according to themes and to make sure we cover those that are most pressing and popular. This webinar is being recorded. The decision of whether it will be shared online is pending. We will notify registrants should the recording become available. And in that case, there will be a link on our website on the page where you registered for this talk. So without much further ado, we'll get to our speaker in a moment. But first, I want to introduce a special guest that we have today. This guest is going to introduce our speaker. Sarah Thompson is the Dean of Continuing Education and the Vice Provost for Outreach and Engagement. Since 2015, Dean Thompson has provided crucial leadership and support to CU Boulder's public outreach and community engagement efforts. The CU on the Weekend series wouldn't be possible without her passionate commitment to creating lifelong learning opportunities for communities across Colorado and beyond. So I want to offer my most sincere thanks to Dean Thompson for her leadership and to congratulate her upon her retirement, which is coming up next month. Thank you, Sarah, for all that you've done for CU Boulder Outreach and Engagement. We are going to sorely miss your oversight and support as a colleague, but we do look forward, hopefully, to seeing you from time to time in the audience. And with that, I'll turn it over to you to introduce today's speaker.
Thanks, David. I certainly will be a part of the audience in the future. It's really been my pleasure to support CU on the Weekend. And indeed, it is my pleasure to introduce today's speaker. S. James Anaya is University Distinguished Professor and Nicholas Doman Professor of International Law at the University of Colorado Boulder Law School. He served as the Dean of the Law School from 2016 to 2021. Professor Anaya has taught and written extensively on international human rights and issues concerning indigenous peoples. Among his numerous publications are his acclaimed book, Indigenous Peoples in International Law, from Oxford University Press, and his widely used co-authored textbook, International Human Rights, Problems of Law, Policy, and Process. Prior to becoming a full-time law professor, he practiced law in Albuquerque, New Mexico, representing Native American peoples and other minority groups. Professor Anaya served on the law faculties at the University of Arizona, the University of Iowa, and he's been a visiting professor at Harvard Law School, the University of Toronto, and the University of Tulsa. He participated in the drafting of the United Nations Declaration on the Rights of Indigenous Peoples and was lead counsel for the indigenous parties in the case of Aguas Tiñu versus Nicaragua. As UN Special Rapporteur on the Rights of Indigenous Peoples from May 2008 to June 2014, Professor Anaya monitored and addressed the human rights conditions of peoples worldwide. Please join me in welcoming Professor Anaya to CU on the Weekend.
Thank you so much, Sarah, Dean Thompson, and let me add my congratulations on your retirement. It's a pleasure for me to be participating in this lecture series. I want to thank David and the others from the Office of Outreach and Engagement who worked hard to put this series together and to include me in it. And I want to thank all of you for taking time on a beautiful Saturday afternoon here in Colorado to share in this event. I'll now share my screen if I can. Let's see if I can successfully do that. Okay, good. It's my sheet. Can you see my PowerPoint there? Developments in International Law Concerning Indigenous Peoples.
Yep, looks good.
Okay, good. Thank you, Dave. Okay. Let me just go over what I'm going to be talking about in my remarks this afternoon. First of all, I'll talk about some basic concepts. This talk is about developing international law in the context of indigenous people. So I'll talk about what we mean by international law. I'm not assuming any knowledge or expertise on that, so I'll just go over the basics of what international law is about and what we understand by that term, and also talk about what we generally refer to as what is generally understood when we refer to indigenous peoples. And then I'll get into the developments that have transpired toward a new area of international law that specifically concerns the rights of indigenous peoples. And I'll also address what motivates these developments. And then finally, I'll talk about and muse about why this area of international law matters in real or practical terms. All right, so as to the term indigenous peoples, there is no official definition that we find in any authoritative document at the international level or elsewhere about what this term means, but we can deduce from the various documents and activities and discussions around this term, what it refers to. And generally, that is the following. Indigenous peoples are generally understood to be culturally distinct communities or nations whose presence or that of their ancestors predates that of the majority or dominant societies in the countries in which they live. They've experienced colonization and related patterns of oppression, the taking of their lands, the suppression of culture, so forth. And these patterns have rendered them in many ways vulnerable today. And so these peoples or groups include, for example, the surviving Indian nations and communities of the Western Hemisphere, the Indian tribes that we find that exist and live here in the United States included, the Inuit and Aleut of the Arctic region, the Aboriginal peoples of Australia, the Maori of New Zealand, and other culturally distinctive groups with similar historical experiences and current situations. All right, that's as to the concept of indigenous peoples. Now, what is international law? Well, just in broad strokes, international law is composed of the norms and related institutions, and particularly the United Nations, that govern relations between independent states. For example, in the areas of diplomatic engagement, peace and security, international trade, access to the sea and ocean resources, and more recently, we see a lot of activity within international law and relations related to cooperation to address climate change. International law also includes norms defining the humanitarian and human rights obligations of independent states in times of both war and peace. So where does international law come from? What are its sources? Again, briefly and in broad strokes, according to the standard doctrine of international law that we find in the various texts and the statute of the International Court of Justice, which is the major judicial organ in the international legal system, the sources of international law are the following. First of all, treaties or conventions, either bilateral, that is between two countries, or multilateral, that is treaties among various countries. And of course, these treaties are formal agreements between countries that are entered into with the intent to be bound to the terms of those agreements. And foremost among these treaties is the most important of multilateral treaties, which is the United Nations Charter. The United Nations Charter establishes the basic foundational norms of the international legal system, as well as establishes the institutions of the United Nations that have so many different functions relating international relations among states and within the international communities. Also, and I'll refer to these later in somewhat more detail, the human rights treaties that have been developed through the United Nations and at the regional level through regional institutions like the Organization of American States. And now there are now numerous human rights treaties that states or countries have subscribed to, including the United States. So that's the first source of international law, bilateral or multilateral treaties. Bilateral treaties, to give an example, would be those bilateral investment treaties that, for example, that the United States has with a number of countries that facilitates an investment in foreign countries or between the two countries. The second major source is what we refer to as international custom or customary international law, and this refers to those norms that develop on the basis of custom or practice among states, independent states, or over time. And we have a number of areas of international law that have developed primarily on the basis of this custom over time. And that includes, for example, the customary international law regarding rights over the sea, diplomatic communities, and also to some extent human rights. And the custom international law doesn't only entail, or many would say not even primarily entail, what governments or states are actually doing. It entails also what they say through their diplomatic correspondence and statements in international settings, or what they understand they should be doing or obligated to do. A third category, which is actually related to international custom, are general principles of law that are common internationally. So these principles we find common in various international legal systems across the globe, in various countries and at the international level. And these would include, for example, principles of due process, equity, or equality. And then, in addition to these primary sources, there are what are referred to as secondary sources. Now, these are judicial opinions, even writings of scholars, and other documents that interpret and help illuminate the content of these primary sources, or that are supplementing the primary sources. So a judicial opinion expanding upon the custom over the rights of the sea wouldn't be a primary source in the international legal system. Unlike our domestic legal system, judicial opinions, the tribunals do not make law, but they interpret it. And so that would be a secondary authoritative source within international law. So that very briefly is a description of the sources of international law. And I very much simplified this description. In typical international law or human rights class, we'll spend days discussing these various sources of international law. So let me see if I can figure out that. There we go. So now I'll turn to developments in international law concerning Indigenous peoples. Indigenous peoples have been advocating for their rights through international diplomacy since first confronted by European powers who came onto their lands or in close proximity. In North America, especially in the US and Canada, or the territories that became the US and Canada, especially, Indigenous peoples insisted on dealing with outsiders through treaties, bilateral agreements of the type I just described. And continuing the practice of the Europeans, the United States negotiated with Indian nations hundreds of treaties. One estimate is 360 treaties that the United States alone negotiated and signed or entered into with Indian nations. But the U.S. and other countries ended treaty making with Indigenous peoples in the late 19th centuries and determined that the treaties were matters and treated the treaties as matters of domestic law only, and eventually indeed denied any character that these treaties might have as sources of international law. And it's in effect the treaties since then have been treated as simply domestic law akin to statutes. At the same time, the countries stopped treaty making, and by the 1900s, really, the international system had developed to exclude Indigenous peoples, really, and this was a manifestation of that. International doctrine considered the treaties within Indigenous peoples outside the realm of international law. So we see writers, international law authorities at the beginning of the 20th century expounding upon how the treaties that were entered into were really not international law in character. They're very revisionist. They look back and say, well, this was just ways of that the colonizers had of placating the natives who really might not have fully understood what they were doing. And a lot of the revisionism in the writing of the early 20th century that purports to be expounding international law doctrine looks back and and deems these treaties in the past even not to have had any kind of international character. That is the treaties with indigenous peoples. So at the close of World War I, most of the independent states that recognized each other's status as independent states, they formed the League of Nations, an organization made up of international organization made up of independent states, which was the precursor to the United Nations, which we're all familiar with, somewhat at least. Now, in indigenous nations or indigenous peoples, consistent with the understanding of international relations at the time that I just described, were excluded from the League. Now, that's no surprise really, in light of the dominant thinking at the time in international law and relations. Indigenous peoples were indeed considered outside what was referred to as the family of civilized nations. And you see the implications there. In fact, indigenous peoples were routinely then and really through the middle of the last century referred to as uncivilized, indeed, as savage. And this has implications, of course, for the way they were treated and the denial of rights. Now, notwithstanding this exclusion of indigenous peoples from the League of Nations, a chief from the Cayuga Nation of the Haudenosaunee or Six Nations Confederacy, which is a confederacy of 6 indigenous nations around the border of what is now the border area between Canada and the United States in the Northeast. Chief Descahay, he went to the League of Nations Geneva on behalf of his people, notwithstanding the exclusion that indigenous peoples generally had experienced from this family of nations represented or participating in the League. Now he went there to petition for membership in the League and to present a set of grievances against Canada for failing to respect Haudenosaunee rights of self-government and for not living up to treaty obligations. Many of the diplomats in Geneva, the representatives of different governments, received the chief cordially. You can see that here in this photo, and it could be said that some, for sure, received him with some curiosity or amusement. And I think that's also somewhat apparent in this photo. And a few governments even supported the Cayuga and the Haudenosaunee in their petition. Those included, interestingly, the Netherlands and Switzerland. But in the end, Chief Descahay did not gain access to the League of Nations to petition on behalf of his people. But still, and I think this is really quite remarkable, his efforts served as inspiration for indigenous people's advocacy efforts in coming years. Decades later, in the 1970s, after the United Nations was formed, representatives of indigenous peoples from within Canada, United States, and many other countries, particularly in the Western Hemisphere, began appearing at the United Nations offices in Geneva, Switzerland, pressing claims for essentially for the survival, the basic survival and self-determination of their peoples. Now by then, the UN was well on its way to developing a robust program for addressing matters of human rights. Now, this was unlike the UN's predecessor, the League of Nations, which had mostly stayed away from human rights, considering that human rights were a matter of domestic concern, not to be talked about internationally. But like I said, the UN was quite different. So it was the United Nations expanding human rights program that provided the opening for Indigenous peoples to be heard at the UN. Now, in fact, one of the founding purposes of the United Nations, as stated in the UN Charter that I referred to before, is to promote respect for human rights and self-determination of peoples. That commitment is stated in the preambular paragraphs of the Charter and in its initial articles. So it's a foundational principle, promotion of respect for human rights and self-determination of peoples. And all, by virtue of being included in the UN Charter, all UN member states, United States, Canada among them, are bound to that principle of respect for human rights. Now, that said, the UN and its member states back in the 70s, when Indigenous people started appearing and advocating at the UN, the UN and its member states resisted and still today continue to resist any claims of full sovereignty by Indigenous peoples. But the UN and UN member states were increasingly open to addressing Indigenous people's concerns in terms of human rights. And that, as we'll see, has been the basis of the development of contemporary international law concerning Indigenous peoples. In 1982, the UN Commission on Human Rights approved the establishment of a working group on Indigenous populations, and that working group was made up of 5 independent experts. Now, the mandate of the working group was to receive information about the conditions of Indigenous peoples and advance international standards about their rights. So a twofold mandate, simply receive information or consider information and advance or give attention, as the resolution establishing the working group said, give attention to the evolution of international standards concerning Indigenous peoples. Now, the working group it took the unprecedented step early on to open its doors to Indigenous people's participation. And I say it was unprecedented because this is an official institution of the United Nations, and its meetings were official meetings of the UN, which is an intergovernmental body. The UN had established by then limited avenues of engagement by non-governmental organizations and certain of the UN bodies, but mostly it was governments or states participating. But the working group, and it's partly because it was at a low level of organization in the hierarchy of UN organization, but nonetheless, it took this step of opening its doors broadly to Indigenous representatives to come and participate in its discussions. And in doing that, it provided an official United Nations arena for Indigenous peoples to express their concerns and to make proposals for new international standards to protect their rights. And what we saw is that more and more groups from across the globe that shared in similar concerns attended the annual sessions of the working group. And the working group annual sessions indeed took on a life that had quite a lot of influence in shaping attitudes within the international system and internationally about Indigenous peoples, and really shifting those attitudes away from seeing Indigenous peoples as needing to be acculturated into the dominant societies and needing to be civilized away from their backward ways, towards seeing them as capable of developing in their own rights, with their own values and with their own cultures intact. That shift really could be perceived in the discussions of the working group. Indigenous peoples were able to promote the shift partly simply by telling their own stories, telling the stories of what had happened to them in the past and the legacies of that oppressive past, or those oppressive elements of the past. and along with presenting their grievances at the international level and this and other forums, it became open to them. Indigenous peoples pressed their concerns at the country level through courts and on the streets. And so we saw a synergy between what was happening at the advocacy internationally and the advocacy domestically through the courts, and like I said, lobbying and even on the streets. And these efforts at home internationally complemented each other. The synergy, as I said, at home, Indigenous people were filing lawsuits, like I said, lobbying and engaging in protests to restrict our rights. And with this advocacy, a clear pattern of grievances emerged, both domestically and through the discussions at the UN working group and elsewhere within the international system. And these grievances signaled ongoing deep-seated problems in the following areas. First of all, just simply violence. I attended many of the sessions of the working group in the 1980s, and I remember hearing about the accounts of Yanomami indigenous peoples in the Brazilian Amazon literally being hunted down by individuals invading their land for gold, and seeing the Yanomami as little more, or maybe not even as much as animals, and hunting them down and killing them. And this was not an isolated situation, and indeed we continue to see violence committed against indigenous peoples in many parts of the world, and women in particular have suffered various forms of violence, and that came to the fore in these discussions at the UN and other forums. Just outright discrimination, racial discrimination of the kind we see against other minority peoples, but also discrimination against indigenous people's cultures and their ways of life. And the suppression of indigenous cultures. We've all heard, or many of us have heard at least, about how the boarding schools in this country and other countries, including Canada, by which indigenous children were taken from their homes to boarding schools where they were forced to speak only English, and not permitted to speak their languages or engage in any of their cultural practices, including religious practices that were very important to it. And we've heard about the very traumatic effects that this had on Native peoples in so many different ways, and continues to have in indigenous communities because of the intergenerational trauma that was inflicted upon indigenous peoples. Also, the suppression of indigenous forms of self-governance. Indigenous peoples who had their own forms and continue to have their own forms of self-governance based on traditions going back centuries, thousands of years, were not allowed to continue these, or at least they were, or in many cases, their self-governance institutions or methods of decision-making, their own laws and customs were suppressed by the colonizing forces, and also by the countries that had grown up around them, and just didn't have room for this sphere of autonomy that indigenous peoples sought to exercise and insisted on, and continue to insist on retaining. And of course, the dispossession of lands and resources. This is sort of the history of countries that grew out of colonial patterns, the taking of indigenous lands through various means. Sometimes it was through treaties, and one can say it was consensual, but more often than not, it was through fraud or simply outright taking through violent means. Today, we continue to see indigenous peoples' lands being invaded in different ways through extractive industries that are authorized by governments to go and take in resources from indigenous lands, by large-scale agriculture, industrial agriculture that is encroaching upon indigenous lands in various places. This has been an issue that indigenous peoples have raised concern about ever since they encountered Europeans coming onto their lands. And then along with the dispossession, encroachment on indigenous people's lands, is the desecration or impediments to their access to sacred places. Indigenous peoples have regard many areas as particularly sacred, and have stories and rituals that are connected to these places, and many of them we can refer to, for example, the San Francisco Peaks in northern Arizona, a place that is sacred to several indigenous nations in the area. Has suffered in the eyes of the indigenous peoples a desecration by the installment of a ski area in that place, and by the use of sewer water, reclaimed sewer water, really to make snow on the San Francisco Peaks areas. Now I'm a skier. I love to ski, but I think at least many of us can agree that to install a ski resort right into a sacred area of an indigenous people is a desecration. So that's just one example of the kinds of desecration of sacred places that indigenous peoples have grieved about, both in international and domestic settings. And then along with all of this, environmental damage to indigenous territories, and environmental damage comes in so many different forms, but most recently among the environmental concerns indigenous peoples have expressed are concerns related to climate change. The melting of sea ice in the north has had devastating effects for Inuit people who rely on the resources that have thrived on the sea ice. And here we can see a dramatic example of how a hunter is left without the sea ice that was once there to survive the wildlife that supported the people, or that has supported the people. Let me just add as an aside that here at the University of Colorado, we'll be partnering with the United Nations in a conference, and it's styled as a summit right here, right now, Climate Change Summit, that will take place in the fall of next year. And issues related to climate change and indigenous peoples will be featured in that as a part of the discussions in that summit. So an implicit or explicit in all these grievances. Sorry, I'm getting ahead of myself here. I always have trouble with the mouse. Implicit or explicit in all these grievances is the failure of governments to adequately address the problems. Not only are these problems happening, but there's the failure of governments to take adequate means. And so this is the basis of indigenous peoples' claims. These are the basis of indigenous peoples' claims to the international system for standards and action to address these issues. And in 1986, the working group on indigenous peoples in response started to draft a declaration on the rights of indigenous peoples. This process of developing a declaration took place with input from indigenous representatives and their advocates who were permitted to participate in the deliberations of the working group, as I described earlier. And also participating were representatives of states. So it was a very fascinating process by which indigenous peoples, their advocates, and representative governments discussed a UN declaration for adoption by the UN General Assembly eventually. Really unprecedented in the way UN documents, declarations, or treaties have been developed in the past or before this. In this discussion, there was a lot of lively debate, and I think that's to be expected given the claims that indigenous peoples were making and the way the international system had developed to really exclude consideration of indigenous peoples historically. But after several years, the drafting went forward. An initial draft was produced by the working group that went to the UN Commission on Human Rights. And here's the room that the Human Rights Commission worked in, and now it's success the Human Rights Council works in. And for another 5 years, discussions took place within the UN Commission on Human Rights until the Commission, which is an intergovernmental body, until the commission eventually agreed on a text and submitted to the UN General Assembly. Now, part of the it was the whole process took, if you consider the beginning of the process, the early 80s, it took a couple of 2 decades and a half really, and that seems like a long time, but really what was happening was that there was a move to shift attitudes, as I said earlier. And it was clear from the beginning that in order for this declaration to have a legitimacy, it couldn't be just something that states declared. The government said, okay, well, this is what we think the rights of Indigenous peoples should be. No, it was understood that that a declaration would have to draw the broad support of not just governments, but also Indigenous people themselves. So eventually, broad, not universal, but broad support for a text finally emerged. So on the 13th of September of 2007, the UN General Assembly adopted the UN Declaration on the Rights of Indigenous Peoples. And I'm very proud of this picture. I took this sitting there observing the deliberations as the vote was taken. I just, it was 2007. I had just acquired 2 weeks earlier the first version of the iPhone, and so here you see it, its results, the results. And this is the exact moment at which the votes takes place. You see the votes being tallied on the board there, and 143 governments voted in favor of the declaration. The vast majority of the UN member states who were present and voting. Now, 11 abstained. Like I said, the support among Indigenous peoples or governments wasn't universal, and regrettably, 4 voted against the declaration. And these 4 included the US, Canada, New Zealand, and Australia. And in explaining their negative votes, each of these countries expressed general support for the core principles of the declaration, but stated they couldn't support the broad, what they saw to be problematic aspects of it, particularly with regard to land rights, stating, for example, well, if we respect Indigenous land rights, as the declaration says, we'll have to give back the whole continent. Of course, that was an exaggeration and not a fair reading of what the declaration has to say. And that became evident as each government in the few years after the declaration was adopted, each of these 4 states reversed their positions and declared support for the declaration, starting with New Zealand, then Australia, Canada, and finally the United States under the Obama administration. And President Obama, in a meeting with tribal leaders at the White House, declared the United States position in support of the Declaration on the Rights of Indigenous people. So it can be said that the Declaration is a consensus document, and it represents a broad consensus of the international community and governments and states within the international community, as well as Indigenous peoples, says, on the fundamental rights of Indigenous peoples. Now, as to the content of the Declaration, it includes 46 articles affirming the both individual rights of Indigenous individuals and the collective rights of Indigenous peoples themselves, or Indigenous nations. And this is an innovation in international human rights law to affirm collective rights of groups and not just the individual rights of the members of those groups. These 46 principles refer to a series of matters of concern to Indigenous peoples and are grounded on core principles of equality, and not just equality of individuals, but equalities of cultures and Indigenous peoples vis-a-vis other peoples or groups. Core principle of self-determination, respect for culture, respect for lands and resources that have traditionally been used and occupied, and principles around social and economic rights that are necessary for a dignified life, such as health, education, and so forth. And so that rights to health and education and other such social or economic rights are affirmed, but with attention to the distinctive cultural patterns of Indigenous peoples. Now, the Declaration is framed with a recognition of the historical and ongoing denial of these rights. So these rights are affirmed, but there's a framing of the document such that it's understood that in fact these rights have been denied. And so an important part of the document is the call that is made for governments and the international community to take affirmative measures to implement these rights, to repair the violations of these rights in the past and in the present, and to do so in collaboration with Indigenous peoples themselves. So the Declaration can be seen as really an instrument of reconciliation, of acknowledging historical wrongs, setting forth a standard for how those what should have happened in the past and what should happen now, and calling upon governments and the international community at large to take specific steps to repair those wrongs and to affirm and implement Indigenous peoples' rights. So it's important to note, though, that, having discussed the content, it's important to note that this declaration, like other declarations, is a resolution of the General Assembly. That is a resolution adopted by a vote of the members, which are essentially all the states, the governments that are members of the UN represented. It's not a treaty. It's not a bilateral treaty of the kind I described before. So it doesn't neatly fit within the sources of international laws I referred to before. So, and because of that, it has been referred to as simply a policy statement or simply as an aspirational document. And of course, it is those things. It is a policy statement, a strong policy statement, and it is aspirational because it shows what should be aspired to. But it's also important to note that this declaration is in fact more than that in international law terms. The declaration, in fact, represents legal obligation for governments in the following ways. First of all, the declaration it can be understood as an extension of the general legal obligation that states or governments have under the UN Charter to respect human rights. It has, in other contexts, been affirmed by tribunals and by UN bodies that declarations of human rights, and particularly the Universal Declaration of Human Rights, are interpretive or fill out, so to speak, the general obligation that governments have to respect human rights. And so the declaration and the rights affirmed in the declaration can be seen as linked to that general obligation and having a legal character in that sense. Secondly, the declaration reflects and expands upon the legal obligations that are established, international legal obligations that are established in the International Labor Organization Convention Number 169 on Indigenous and Tribal Peoples, which is a multilateral treaty that was developed parallel to the developments at the UN concerning the declaration. Now, when that discussion was getting going that I described at the UN around Indigenous people's rights, and the International Labor Organization took note and revised an older convention that it had that was developed because of concerns for the slave-like conditions that many Indigenous peoples had been living under. And it revised that older convention and adopted its Ilo Convention Number 169. Now, this convention is a multilateral treaty. The older Ilo Convention of 1957 had a very assimilationist tenor, characteristic of that time. Its thrust was to assimilate Indigenous peoples without respect for necessarily for their cultural patterns. So the International Labor Organization went about to revise its convention in light of what was happening at the UN and developed its convention number 169, which which takes the same philosophical tone that the Declaration does, although not in as sweeping terms. It does affirm Indigenous peoples' cultures, their institutions of self-governance, their land rights. So the Declaration expands upon these and really is a reflection of the norms that are incorporated, and an expansion of norms that are incorporated in a legally binding treaty. And that treaty is ratified by most of the governments and states in the Western Hemisphere and other countries. Not the US or Canada. And that's largely because the Indigenous peoples in US and Canada have not advocated for adoption or ratification of that convention in these countries, seeing that convention is not being as far reaching as they might like, not as far reaching as the Declaration on the Rights of Indigenous Peoples. But nonetheless, the Declaration does have the same tenor, and it reflects what is in that international instrument, that binding treaty, and more. Now, thirdly, many of the provisions of the Declaration are customary international law or general principles of law. And remember, that's another category of sources. Those other categories of sources of law. Now, how is that the case? Well, the principles that are affirmed in the Declaration can now be seen affirmed in multiple international instruments. The various instruments that coming out of the environmental movement and the environmental conferences, for example, have provisions regarding Indigenous peoples. The concluding document in 2014 of the World Conference on Indigenous Peoples that was held by the General Assembly. The concluding document going back to the 1993, even prior to the Declaration, the concluding document of the documents of the World Conference on Indigenous Peoples, documents of other international institutions, the World Bank, the Organization of American States, American Declaration of the Rights of the Peoples. All these follow the same pattern as reflected in the Declaration, and then we see the Declaration starting to have effect in actual state behavior in various parts of the world. So I floated this theory way back in the 90s, even before the Declaration was adopted, that they were emerging norms of customary international law. But now numerous scholars and even tribunals have recognized that there are customary international law norms concerning Indigenous peoples, and that the Declaration incorporates many of them. So the Declaration can be seen as having legal character by incorporating customary international law. And then finally, we see the Declaration coinciding really or being interpretive of the application of core human rights principles that have long been included in major international human rights treaties. The Declaration wasn't just created out of thin air. It was built upon core human rights principles. And these have been included in major international human rights treaties for some time. So let's take the core principle of equality that I mentioned earlier. Equality and non-discrimination, these norms or this principle is found is a foundational norm in all of human rights treaties. Virtually every human rights treaty begins with the affirmation of equality of people and the norm of non-discrimination, the basis of race, gender, and other identities. And especially relevant in this regard is the International Convention on the Elimination of All Forms of Racial Discrimination. And what we see is the same equality norm coinciding with the Declaration. All Indigenous peoples and individuals are free and equal to others, individuals and peoples. And we see that the committee that is charged with implementing the convention that I just mentioned, the race convention, giving opinions about that convention and its implications with regard to Indigenous peoples, with those opinions roughly approximating what the Declaration says. We see the same with self-determination. That's a foundational norm in major international treaties, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights. And Article 2 of the Declaration takes the same language of these instruments and affirms that all Indigenous peoples and individuals are free and equal to other individuals. Sorry, that there's a mistake there. The Declaration Article 3 says that Indigenous peoples have the right of self-determination in the same terms as these covenants do. And Article 4 refers to rights of self-governance and autonomy. So we see again a building on the basis of these core human rights principles. The same with regard to culture. The International Covenant on Civil and Political Rights has a provision affirming the rights of minorities to their culture. The UN Declaration affirms culture in a number of ways. The Human Rights Committee, which interprets Article 27 and that treaty, it's a UN body, has interpreted Article 27 to have implications much like articles that we find in the Declaration on the Rights of Indigenous Peoples. And then finally, by way of example, property, this notion of property that is affirmed in human rights instruments, treaties as a human right, including in the American Convention on Human Rights and the Charter of the Organization of American States. These international treaties uphold or protect the right of property. And in a number of cases, including the Awastini case that Dean Thompson mentioned earlier that I litigated, the Inter-American Court of Human Rights has interpreted this general human right to property to include Indigenous people's own customary land tenure systems. And so that in protecting the right to property, international law is deemed to protect Indigenous people's customary land tenure and traditional rights over lands and resources. In much the same way that we see included in the Declaration. So what we see is that this body of international law on Indigenous peoples with the Declaration derives from with the Declaration on the Rights of Indigenous Peoples, it derives some basic, widely recognized human rights. And the direct declaration itself reflects those widely recognized human rights. Sorry, I'm having trouble with the mechanics here. Let me start off. So what we see is that the Declaration on the Rights of Indigenous Peoples derives from basic, widely recognized human rights. And accordingly, the Declaration is part of a body of international law on Indigenous peoples that is grounded in a number of international human rights treaties. And as I said earlier, it's also part of a broader pattern of international affirmations of Indigenous rights that constitute and reflect, at least in part, customary international law or general principles of law. So there's this body of international law. It includes the Declaration and these other instruments that I have mentioned. So at its core, what is this body of international law about? I've referred to various aspects of it, but at its core, this body of international law affirms the rights, sorry about that. At its core, this body of international law affirms the rights of Indigenous peoples to survive as culturally distinct communities, to pursue their own destinies under conditions of equality, and to maintain their connections with traditional lands. And it also requires that governments actively work to protect these rights. So that's it in a nutshell, what this body of international law on Indigenous peoples is about. And the question then comes, how does this body of international law matter? You know, okay, you have this body of international law, but how does it really matter beyond the halls of the United Nations or the literature that's produced around these issues and concerns? Well, I'm gonna have a shot at answering that real briefly in the time I have available. So I'd like to get to questions pretty soon. First of all, this body of international law, it sets a standard of behavior towards Indigenous peoples that governments are obligated, as a matter of international legal obligation, to follow. Now, in most cases, governments don't meet these standards, so reforms are needed. Now, you might say, well, governments, why would they follow international law? Well, they do. I mean, they enter into treaties, they enter into these obligations with the intention of following them, and most of the time they do eventually, and so we see in fact reforms happening based on this standard in countries across the globe, little by little. Reforms through legislation, for example, in Canada, legislation was just adopted making the UN Declaration a benchmark for government action, such that all federal agencies are required to review their policies and practices in light of the standards expressed in the UN Declaration of Rights of Indigenous Peoples. This is legislation just adopted in Canada. It can also happen, these kind of reforms to conform to this international standard can also happen through executive action, that is the action of executive actors. And we're starting to, in fact, see this in the US, where sometimes referring to the declaration, but even if not following the basic policies in the declaration, executive actors are reforming practices to come in line more and more to the standards of the declaration. And also courts can apply these international standards. Now it varies from country to country the way that courts treat international law, but throughout Latin America, for example, we see the declaration and various parts of international law being applied directly by courts with regard to indigenous peoples' rights. And so we see major reforms happening in Colombia, Ecuador, Chile, Costa Rica, and recently Mexico. In the judge-made law, for example, based on these international standards. Now, that's not saying that everything's fine in those countries and everything's has changed, but at least the legal framework, the legal landscape has dramatically changed based on these international standards. Now, in the US, international law is a little more complex in the way it's treated by the courts, but at the very least, the declaration can, and it has been in a number of cases in the United States, used as an interpretive backdrop to interpret domestic norms concerning indigenous peoples. For example, interpretation of the scope of the US trust responsibility that exists under US federal law towards indigenous peoples. That the content of that responsibility of federal actors can be interpreted in light of the declaration. Then we can see that the declaration, or this body of international standards, can also be a framework for it says 3 here, but it's really 2, a framework for international tribunals and other institutions to address indigenous people's concerns. As I've sort of indicated, the international system has a number of institutions that work to promote and implement indigenous people's rights, that work with governments. Dean Thompson mentioned that I held the position of UN Special Rapporteur on the rights of indigenous peoples. Now, this is one of the low-level institutions, but nonetheless, it is an institution that has the power and the authority to engage governments directly about their behavior towards indigenous peoples on behalf of the UN. I had no, in that capacity, any authority to bind governments, and that would be really outrageous if anybody suggested that I should or would. But the institution of the Special Rapporteur has the authority to engage with governments, and the declaration and other sources of international law provided the framework for engaging with governments. And we see that as being the case for multiple UN institutions, the various committees that exist to promote directly with governments human rights. The declaration and other international sources provide the framework by which these different UN agencies engage with governments and others to promote human rights. And let me just add that as I'm sitting here, the declaration and these international standards are also educational devices. We see still so much ignorance in the US and other countries about indigenous peoples. I think many Americans, maybe even the average American, thinks that Native people really don't even exist anymore. What they know of them is by observing or is through the mascots that sports teams have. That's the imagery of indigenous peoples. And these international standards, the Declaration on the Rights of Indigenous Peoples in particular, can be used as as educational devices at all levels of, through all kinds of education. So I thank you for listening to me, and I'm happy to answer any questions you have or hear any comments you might have.
Thank you so much, Professor Anaya, for that overview. So I'm going to do my best to provide a voice for our audience, getting this into a back and forth discussion. Folks who have contributed questions, again, it's that Q&A icon down at the bottom of your screen. You can submit questions and we will moderate those and get them into the mix for a discussion here with the time we have left. So early on, we got a question that has to do with terminology from a participant named Lisa. When are we going to finally stop calling the native peoples in the US Indians? Isn't 500 years of using this erroneous name enough? And I think this is a really interesting question, Professor Anaya, that you probably can give us some insight into. I know that some of the folks who are professionals in the law school refer to the area of law that they do as Indian law, which I was surprised to learn that. So what's the status of that word and how people refer to indigenous groups in the United States?
Yeah, I mean, it is a discussion that's happening, but the fact is that many Indian tribes or native peoples, still use the term, and many individuals do, and it is sort of a term of art that is still with us, and if I heard a big groundswell from native peoples themselves, then I think there would be reason for us to change, to work to change that term of art. But yeah, it's a somewhat of a term of art, and it's one that many tribes, if not most, continue to themselves use. Our program at the concerning indigenous peoples at the law school is called the American Indian Law Program, and it has been called that for many years, and it's a program that serves our indigenous students and is substantially run by them, and we just haven't seen them, our native students, advocate for changing the name of that program. So that's just one indication of the attitudes that exist out there. So it is a valid concern. It is a valid point.
Great. So a couple of questions related to what the declaration means in terms of practical matters. One has to do, this is from an anonymous participant, are the affirmative rights that were included in the declaration from the UN inclusive of things like reparations for groups, or do they simply acknowledge wrong and state that things will be improved in the future? Basically, are they mostly forward-looking or backward-looking, these affirmative rights?
There is a provision, calling on states with regard to land rights to address land claims, to develop means to address claims to lands and other kinds of claims, and notably with regard to each of the articles. For example, the articles regarding language and culture, but not just those. Each of them, there's the affirmation of the right. Indigenous peoples have the right to their own cultures, their languages, and religious practices, for example. Then, the next part of the article is a statement that states, meaning government, shall take measures in cooperation with indigenous peoples to implement this right. So it really, the declaration throughout emphasizes the need for governments to take action to implement these rights, with the understanding that sometimes that's going to require not just ensuring that the rights are enjoyed in the future, but actual reparations and remedies for violations of those rights. That's very much present in the declaration and other sources of international law that I mentioned.
So a participant named Kermit asked, what are some specific things that have changed in the USA based on the UN Declaration of Indigenous Rights?
We've seen, for example, reforms in the education department, where there's a lot more in the Department of Education, where, and other parts of the government, the Interior Department, where it was a lot more top down, meaning, from Washington down to services that were provided, very much controlled by government bureaucrats and without the kind of participation that is due from Indigenous peoples we said themselves. So we see a real, I would say, since 2008, 2010, that time period, since then we see a real shift in the way that the federal bureaucracy works in providing services towards Indigenous peoples or in delivering the programs that the federal government has. We see more openness on issues of land, allowing greater control and even return of some lands to Indigenous peoples. And we see a lot more support for Indigenous culture and education that is sensitive, that is appropriate to Indigenous peoples. There really has been a shift. Now, that started to take hold with the Obama administration. I mentioned that Obama declared support for the declaration. The Trump administration was I should say, how should I say this? Didn't really do much to reverse the changes that it made in the programs. Didn't really do much to help move the progress forward either. But now with the Obama administration, we see much more of the kind of progress that we were seeing under Obama.
Great. And I think just for clarification, I think you said the Obama administration a moment ago. Professor Nye, did you mean the Biden administration?
I meant the Obama administration back in, back in
Okay.
2010, but currently, yes, the Biden administration. Sorry about that.
No, so there's a set of questions that have come in that are related to say corporations and industry. And I think that's an interesting issue when you're talking about a system of international law that the basic units of it are states.
Mm-hmm.
So what are the implications of this UN Charter for Issues related to non-state actors like corporations in terms of development? Someone mentioned, natural resource development in terms of oil and gas on Indigenous land. Are there implications for industry and corporate actors?
Yes, very much so. I mean, there's a whole body of activity within the international arena, within the UN in particular, around the responsibility of business enterprises with regard to human rights generally. And more activities are happening within the UN to hold companies accountable to respecting human rights, and more companies are at least expressing, not to mention their behavior, but expressing support for that principle that they should be following human rights norms. And part of this concern with business enterprises is regard to their treatment of the human rights of Indigenous peoples. And so when there are discussions about the human rights of Indigenous peoples, references are then made to the Declaration. So the Declaration of the Rights of Indigenous Peoples and the other sources are very much part of that discussion about the human rights responsibilities of companies. And in fact, we see companies, the major companies, in particular the oil and gas and mining companies, moving to adopt policies on Indigenous people's rights that are more or less consistent with the norms in the Declaration. Now, you see a lot of resistance by many of them to going as far as the Declaration does in terms of robust rights to lands and to consultation or having the capacity to say yes or no to development in their traditional territories. But there was substantial movement among corporate actors, at least in principle, and in adopting policies that would adhere or that are in some way reflective of these international standards. Now, the situation on the ground is still far from adhering to the rights that we see affirmed in the Declaration and other sources. Companies still have not even assimilated their own or adequately assimilated their own policies into their operations. So there's still a lot of work to do. But at least in principle, what we see is the international human rights regime that exists within the UN system, addressing not just state behavior, but also the behavior of business enterprises, and more working to hold business enterprises accountable. And we see that having some effect on companies in their actions, including with regard to Indigenous peoples.
Thank you. A question about international law that is more general. Does our current framework for international law treat nations differently based on how democratic they are or their human rights record? Are different countries treated with different degrees of legitimacy based on this? And how does that affect their relationship with Indigenous nations within their territories?
Okay, well, in a formal sense, international law treats each state equally, and doesn't at the outset concern itself with their internal governance systems, whether or not they're democratic. Yeah, now that's the formality, right? Each state is an actor equal to all others. But in practice, with regard to certain issues, right? With regard to certain issues, including human rights, including trade, increasingly, issues of legitimacy are very important in relations among and between states, and those issues of human rights and democracy and rule of law increasingly enter into discussions that aren't purely about human rights, including, like I said, for example, trade regimes. Now, some would say they're not sufficiently present in those other discussions, and I tend to agree. But we see movement in that direction. But of countries that have abominable human rights records and are anything but democratic, are members of the United Nations and have the same rights and privileges of membership as others, and that's that formality that I was referring to, or that's one of the one reflection of that formality that I was referred to earlier. But in their influence and their capacity to engage in a range of of matters in a practical sense, those deficient human rights records and lack of democratic legitimacy, those factors do enter in.
So a question related to coercion, and this might apply to both state and non-state actors, I'm imagining. Michael asks, can you speak briefly to the serious issue of coercion by corporate and state entities in pressuring and tempting with money, quote, prior informed written consent from Indigenous peoples?
Coercion, in what sense? Maybe if I could get a little.
Michael does have a follow-up on how the problem of coercion is perceived and addressed by UNCHR, Special Rapporteur, and the HR Commissioner. I'm afraid that I can't elaborate any further than
coercion. Yeah. Well, I was the Special Rapporteur on Indigenous people, so maybe I said something about that, or one of my colleagues did. Yeah, I mean, coercion is a violation of human rights in most contexts, and certainly would be with regard to Indigenous peoples if they were coerced into any arrangement. And, I mean, there is a standard of free prior informed consent that's embedded within the Declaration in many of its provisions. And, simply the standard is that whenever this government is going to take any action that affects Indigenous peoples, it needs to consult with them with the objective of achieving their free prior informed consent. So that certainly is against any kind of coercive action taken towards Indigenous peoples.
Thanks for that. And Michael, I hope that I didn't, confuse the question in some way that made it more difficult to parse. So Darcy asks, what country, in your view, if there's a standout, has done the best in terms of making advancements in how it treats its Indigenous peoples? Are there any good examples?
I've often gotten that question, and I'm very reluctant to answer it in specific terms, because really I think the point is that every country should be taking where it is, and every country needs progress. We see progress in a number of places. Really, I would say throughout the Western Hemisphere, at least, we see significant progress in policies that are more adherent to the international standards that we've seen develop. But everywhere, there's also a long way to go. Canada, you can say, stands out because it has this legislation that explicitly adopts as a standard the Declaration and requires all federal agencies to review their practices and with a view toward conforming with the Declaration. But Canada has a long way to go. It still needs to account for a lot of wrongs that include violent acts against Indigenous children, in the not too distant history, issues of violence against women, missing women and children, women and girls. And there's a lot that Canada has to account for. So even where you have a country like that does something that is very progressive and seems to embrace wholeheartedly the international standard, you see a lot of room for action to fully reach that point of reconciliation that I mentioned.
We've received a couple questions related to the rights of nature. And I'm not sure, is this a familiar framework?
Yeah.
Yeah. So participants have asked, for example, is there any discussion of amending the Declaration on the Rights of Indigenous Peoples to include the rights of nature? Or someone even suggested the possibility that it might replace the existing declaration. What are your thoughts on that?
Yeah, well, the rights of nature, I mean, that they are affirmed. Rights of nature are appearing more and more in domestic constitutions. Bolivia, Ecuador, just a couple of countries that I could mention, where you do see, rights of nature. And that's distinct from what we see at the UN now, which is affirmation of human right to a safe and healthy environment. In this latter affirmation, it's still the human being or a group of human beings that are the subjects of the right. Whereas when we talk about right of nature, nature has the right regardless of, or not regardless, but wholly apart from or as an independent matter from any impact or benefit to individual human beings. It's quite an innovation. I think it's an interesting innovation and one to think about, and it's quite useful. It's an innovation that's quite useful because, for example, if a river has subjectivity, meaning it is a subject of rights, then regardless of what humans benefit derive from that river, that river is entitled to protection. And we see, for example, recent litigation in New Zealand that affirms precisely that with regard to a river that's important to Maori people. It's the river itself that is entitled to protection, that has rights to nature. And so I think that can be important and quite useful, but I don't see necessarily amending as a practical matter, that's very difficult to do. I don't know that UN declarations have ever been amended. But in principle, I don't know that would be very useful, or much less replacing it. I mean, the Declaration is about Indigenous peoples, and it's about their human rights, including their collective human rights, and that's a value in and of itself. I mean, the rights of nature could be complementary to that, but not to replace it or displace it.
So we are almost out of time here. I think we can get another question or two in. But Professor Anaya, how would someone get involved in working on issues related to Indigenous rights and international law? Do you have any advice for someone who is passionate about this issue and how they might take action?
Well, there are all kinds of volunteer, opportunities with different non-government organizations, increasingly environmental organizations, those particularly that work internationally, also do Indigenous rights. I was just asked by an environmental organization working in the Amazon to help them in a case having to do with oil development on Indigenous peoples' lands in the Amazon. So environmental organizations, organizations of support for Indigenous peoples, like one right here in Boulder, Cultural Survival supports Indigenous peoples across the globe. There are others. At the law school, we have student organizations that work on these issues. We have different projects through our American Indian Law program, and other law schools have that. But in particular, to get involved in international law and international legal advocacy, now a law degree is useful, if not necessary. So go to law school and take the courses dealing with these kinds of things. And I would also add, understand that it's really Indigenous peoples who are the ones who are out front on the advocacy issues. They have agency on these issues, and so there always needs to be a deference to that. Secondly, it takes a time and experience to become familiar with these issues and with the complexities of them, and so taking time to gain that experience and learning is important.
Thank you. So an anonymous participant asked, how can we learn more about the fall 2022 conference or summit that you mentioned? What's it called?
Yeah, it's Summit on Climate, on Human Rights and Climate Change. It's Summit on the Intersection of Human Rights and Climate Change that we're holding here, and I think it's the term "right here, right now" is somehow in the title. I should know that. I'm involved in helping to organize it, but so a Summit on Human Rights and Climate Change under the banner of "right here, right now," sort of the idea that we need to take action. This summit is just now in its early stages of planning, and there will be information on it, I think, early in the year about specific dates. We have tentative dates, and I think I hesitate to mention what those are because they're very, very tentative, but late fall, let's say. And I think, like I said, by early in the year, there will be more specific information about the event. And one thing I think is fairly certain about the event, that it will be broadly open to the public, at least most of the sessions of it. So it will be a good opportunity to engage with people around the world from different backgrounds, from different perspectives about the multiple issues around climate change, and particularly from the perspective of the impact of climate change on human rights.
Great. Well, I'm afraid we are running out of time here, so I'm going to just say a few things to close us out. First, and obviously, thank you so much, Professor Anaya, for sharing your research with us, your scholarship, and action in this area. We're really, really grateful for your time and your expertise, and for the opportunity to learn more about this vitally important scholarly work that you do. We really appreciate it, and it's just such a great contribution to the intellectual community that is built through these programs. We really appreciate you, so thank you.
Thank you.
I think that's where the applause, would come in if we were in person. it's happening in people's houses in front of computers around the world.
I'll add to that as well. I just want to really sincerely thank you, Professor Anaya, for really interesting, informative, and engaging presentation. And thank you for sharing your expertise with all of us. Thank you so much.
Thank you. Thank you very much. Thanks for the wonderful questions too.
So a couple last things for our audience here. Thanks to all of you for joining us today, for your time and attention, your participation through those excellent questions that Professor Anaya just mentioned. I'd especially like to appreciate, again, Dean Thompson. Without her support, this program would not be possible. We're so grateful for her. And also for the back-end team, Emily Musumeci and Gretchen Minikheim, who have been handling the technical aspects of this. They're part of the Office for Outreach and Engagement team. Thanks to both of you for your technical support. All right, so you all participants will receive an email with a link to a short Google survey tomorrow. We very much appreciate your feedback. There's the opportunity there to weigh in on topics you'd like us to address in future programs. We take that feedback very seriously. We will notify all of the registrants by the end of the day on Monday whether a recording of this program will be available online. We haven't made that determination yet, but we will notify you all on Monday about whether that will be available. And so this is the final installment of our fall series for this virtual lecture series. The spring 2022 series is being planned as we speak. Registration will be required for those programs in advance online. So keep an eye on that. You can sign up for our listserv to find out more about these programs. And that will also be a question on that survey if you complete that feedback survey. So sign up for information and you'll hear about the spring lecture series. Thanks so much for attending, and we look forward to seeing you all on the weekend in the future.